This is Bloomberg Law with June Grasso from Bloomberg Radio.
The illegitimate dictator Maduro was the kingpin of a vast criminal network responsible for trafficking colossal amounts of deadly and illicit drugs into the United States.
President Donald Trump announced the stunning middle-of-the-night military operation that captured now ousted Venezuelan President Nicolás Maduro and his wife, who will now face charges in a narco-terrorism case in a Manhattan federal court. It will be an extraordinary legal battle with major geopolitical ramifications. But little was said about Maduro or the drug trafficking charges during the nearly hour-long press conference on Saturday. The focus was on the running of Venezuela and on oil.
Well, we're going to be running it with a group, and we're going to make sure it's run properly. We're going to rebuild the oil infrastructure, which will cost billions of dollars. It'll be paid for by the oil companies directly. They will be reimbursed for what they're doing, but that's going to be paid. And we're going to get the oil flowing the way it should be. As you know, it was just a minor flow. It was actually a minor flow for what they have.
During an initial court appearance on Monday, both Maduro and his wife pleaded not guilty to the charges. Maduro was defiant, saying, "I am a kidnapped president. I am a prisoner of war." My guest is former federal prosecutor Jimmy Gurule, a professor at Notre Dame Law School. Jimmy, initially defense attorneys are going to challenge the legality of the court's jurisdiction over Maduro. If his capture breached international law, can that be used as a grounds to avoid prosecution?
Well, it's a good question. I think the invasion of Venezuela both violates U.S. constitutional law and international law. From a constitutional law perspective, this was an act of war. You know, the invasion of Venezuela, the toppling of their president, his apprehension, I think the bombing of Caracas, I think upwards of 30 or more of President Maduro's security guards were killed. I think it's clearly an act of war. And the Constitution is very clear that Congress must give authority for this type of action, and Congress did not. I mean, Congress was made aware of this action as it was taking place or shortly after it took place. So I think that there's an issue there. With respect to international law, I think there's two important aspects to that. One is the illegality, but the other is the criminality. I think it's both an illegal act and a criminal act. Under the UN Charter, specifically Article 2, Section 4, states are prohibited from exercising, the use of force within the territory of another state to impact the political independence of that state. So it's a violation of the UN Charter. But I think perhaps even more importantly, I think it's a crime of aggression. So the crime of aggression, it's an international crime. It was first prosecuted by the Nuremberg Tribunal following World War II, and it was labeled a, quote, supreme international crime, end quote. So it's the most serious criminal act of aggression. And the crime of aggression is a crime within the jurisdiction of the International Criminal Court. So what I wonder there is whether or not the international law, criminal law aspects of this act of invasion would rise to the level of a due process challenge under the Fifth Amendment. The argument would be that it shocks the conscience, for the U.S. military to go into a foreign country in the manner that it did, killing again 30 or more of the President Maduro's security guards, bombing the capital city. Does that shock the conscience? Is this something that the court should say, we don't want to have anything to do with? We don't want to explicitly or implicitly support this kind of government action moving forward, and therefore, we're going to dismiss the case on those grounds.
Hasn't the Supreme Court, though, held that criminal defendants generally can't challenge federal courts' authority to preside over their cases by arguing that they were brought to the U.S. illegally?
That's true. That's true. So there has been, court rulings to that effect, that simply the fact that you were brought to the country, that you were apprehended in a foreign country and brought to the jurisdiction of the United States in that manner does not support a due process violation. But I think there are degrees of action here. So there's one thing about surreptitiously maybe having agents of the government go into a foreign country, snatch the defendant, remove him from the country, bring him to the United States. It's another thing and a much greater degree of misconduct and illegality to go into the country with military force, bomb the country, kill government security agents, kill civilians. And then in addition to that, say that, as Trump has, we're going to run the country for the foreseeable future. We're going to control the petroleum industry, and we're going to control that. And so there we kind of move to an actual kind of occupation of the country. So I think that degree of conduct makes this case particularly unique, even unique from what we've seen in the past, let's say with the General Noriega case and the invasion of Panama. I mean, so, that has been raised as, well, look, the U.S. went in to Panama, they arrested General Noriega, and that was upheld by the courts, and no harm, no foul. I mean, it wasn't struck down. Noriega was prosecuted, and none of the legal defenses raised prevailed in the Noriega case. But here, I think there are some similarities, but there are some differences. And I think one major difference here is where the Trump administration is saying, we're going to run the country. That wasn't the case in Panama. The Bush administration put a person in place who was the opposition leader of the country. That person ran the country, not the United States. And the United States didn't take over natural resources the way that the president is proposing to be done in this particular case.
I noticed that at the press conference even, Secretary of State Rubio is saying something different than what President Trump is saying, but we'll see what actually happens. Now, there's also the defense might challenge the court's jurisdiction based on head of state immunity.
And of course, that defense failed in the Noriega case. But Noriega was the de facto head of state. He wasn't the elected, head of state. And here, Maduro was, even though, of course, there are substantial claims that it was a fraudulent election and he isn't the truly elected head of state. So I think that's going to be an issue. It's going to be a thorny issue. And that one, I'm not confident that defense lawyers are going to prevail on that claim.
Is there any place here at all for the Supreme Court's opinion that President Trump, American presidents are immune from criminal prosecution for official actions while in office?
Well, I think it's certainly an argument that the defense is going to raise. They're going to say, well, look, even the United States Supreme Court has held that its own president is immune from prosecution for official acts while serving in office. The counter argument is going to be, well, drug trafficking isn't an official act. Trafficking in weapons isn't an official act. And therefore, immunity doesn't extend, to that type of conduct, that type of criminal conduct. But I think at the end, what we're going to see is that there are a number of very complex legal issues that are going to be raised by Maduro's defense lawyers that are going to delay the jury trial for months and months to come.
Yeah, and another thing, so Trump orders this operation to capture Maduro just a few weeks after he pardoned the former Honduran president, Juan Orlando Hernandez, who'd been convicted in court on similar drug trafficking charges. So can the defense use that and argue perhaps selective prosecution?
Well, I think it certainly undermines the president's claim that this was solely a law enforcement action, that the motivation was simply to bring to justice this president who was responsible for, tons of illicit narcotics being trafficked in the United States. So I think that argument is hard to make when just a few months ago, the president went ahead and pardoned another former head of state who was criminally tried and prosecuted. The former president of Honduras was responsible for assisting, aiding and abetting, conspiring to traffic in over, I think, 400 tons of illicit narcotics in the United States. He received a 45-year sentence, which certainly highlights the severity of his criminal conduct. His conviction was affirmed on appeal. He received due process. There's no claim that there was anything wrong with the trial, that he did not receive a fair trial. But yet the president pardoned him. So what kind of evidence would justify pardoning such an individual? So I think that undercuts the claim that this was just a legitimate criminal enforcement operation and really raises the issue, well, then if that wasn't the true reason why the United States went into Venezuela, then what's the true reason? And then that raises the question of oil. Was it just all about oil? At the end of the day, is the law enforcement argument simply a facade, a disguise for the real reason, which is to take control of Venezuelan oil reserves?
It sounds like there's a lot of motion practice ahead.
There may be a serious question about whether this case actually goes to trial. And the reason being is that through criminal discovery, there could be requests for discovery of evidence that perhaps is classified evidence. And under the Classified Information Procedures Act, the defendant has a right to evidence to support his or her defense, even if that evidence is classified. So there could be a real interesting question about balancing national security interests with respect to classified information and the defendant's interest in receiving a fair trial. If at the end of the day, the court concludes that the defendant's interest in receiving a fair trial, which is a constitutional right, supersedes the classified national security interests concerns, then the prosecution, the Department of Justice, is going to have to make a hard decision. Do we want to disclose that classified information? Is that going to be so harmful to national security that we would prefer to not go forward with the prosecution or try to resolve the case pursuant to a guilty plea based upon reduced charges, maybe a reduced sentence? So I think there's a serious issue kind of lurking out there in that regard. And then at the same time, I wonder whether any of the evidence to be used against Maduro at trial was obtained pursuant to an electronic surveillance warrant under the Foreign Intelligence Surveillance Act. And if that's the case, then there could be extensive litigation on whether that evidence should be disclosed and whether that evidence was lawfully obtained pursuant to a lawful FISA warrant. And that could be another reason for the government willing to enter into a lesser guilty plea.
Coming up next, what kind of evidence might be presented at trial? This is Bloomberg. The U.S. government's most consequential prosecution of a foreign head of state in decades kicked off in a Manhattan courtroom today. Ousted Venezuelan leader Nicolás Maduro and his wife pleaded not guilty to the charges against them. Maduro is facing charges of narco-terrorism conspiracy, cocaine importation conspiracy, and possession of machine guns and destructive devices. Last month, President Trump pardoned another leader, former Honduran President Juan Orlando Hernandez, who'd been tried and convicted of similar charges and was serving a 45-year prison sentence. Here's Trump's explanation of that pardon.
The man that I pardoned was, if you could equate it to us, he was treated like the Biden administration treated a man named Trump. That didn't work out too well for them. This was a man who was persecuted very unfairly. He was the head of the country. He was persecuted very unfairly. And there are a number of them. And we felt that it was a very unfair situation that happened to him.
I've been talking to former federal prosecutor Jimmy Gurule, a professor at Notre Dame Law School. Jimmy, tell us a little about the charges against Maduro and the similarity to the charges the Justice Department leveled against him during the first Trump administration in 2020.
They're very similar, and so again, it's primarily kind of enabling drug trafficking, enabling drugs to be trafficked from Venezuela to the United States. So drug trafficking charges and then weapons trafficking related charges. And basically, the Maduro was part of a conspiracy with drug organization, drug cartels to traffic illicit drugs into the United States.
It appears that some of the government's evidence against the Maduros includes recordings of DEA agents and relatives of Maduro, and also there may be cooperating witnesses because, for example, Venezuela's former military intelligence chief pleaded guilty to narco-terrorism and drug trafficking charges in the case in June of 2025. And a Venezuelan general also pleaded guilty. Does it seem as if the government does have some strong evidence?
Assuming that they do, this would not be the kind of case, because it's such a high-profile case. The government is wanting to ensure that it obtains the conviction against Maduro. The last thing the government would want would be for the jury to return a verdict of not guilty, acquitting the President Maduro. And so I suspect that there are members of the drug cartel, members of the drug conspiracy that are going to testify against Maduro. The question then is that what promises were made to them in exchange for their cooperation? And under a very important Supreme Court decision called Brady versus Maryland, the U.S. government has an obligation, a constitutional obligation, to disclose exculpatory material evidence, including impeachment evidence of critical government witnesses. And so the government's going to have to disclose whatever deals they cut with these witnesses to testify at trial. And once that evidence is received by the defense, that's going to be used to impeach those witnesses at trial. And it could really undermine the credibility of their testimony. So that's another big issue.
Yeah, I was wondering how difficult it would be to tie all this to Maduro. Do they need direct orders from him? What kind of proof would they need?
That's always a difficult challenge in drug conspiracy cases. It's easy to ensnare and prosecute and convict the lower level members and even mid-level members of the drug conspiracy. It's much more difficult to prosecute the individuals that are at the top of the conspiracy. And the reason being is because they are so insulated. They're so insulated from specific drug transactions. They have people that are acting on behalf of the drug kingpins. And so it's very difficult to uncover direct evidence of the drug kingpins' participation in the conspiracy. And so that's going to be another challenge that the Department of Justice is going to face in this prosecution.
In a case like this, for a district court judge to say there's no jurisdiction here, let him go, realistically, would it take a lot more than a normal low-profile case?
I don't think any federal district court judge is going to want to be criticized for doing that, that you dismiss the criminal charges against a former head of state who was charged with, trafficking in large quantities of illicit narcotics. And then on top of that, of course, there is a kind of a presumption here in favor, so the courts traditionally grant substantial deference to the president, to the executive, in the field of national security and foreign affairs. Substantial deference. So that's the starting point. That's the legal standard. That's the floor. We're going to give you great substantial deference with respect to the action taken. So it would have to be something very significant, very outrageous to kind of overcome that legal standard of substantial deference and cause the court to intervene and dismiss the charges.
Do you think it could be as long as a year before this, if there is a trial, before this gets to trial with all the preliminary motions and discovery?
I think it's very realistic. I think it's very reasonable to assume that when we start looking at this long list of potential pretrial motions that are going to be filed in this case, the complexity of those legal issues, the discovery that's going to be at issue in this case, I would not be surprised if the trial date, the commencement of the trial, doesn't begin until sometime in 2027.
Do you see broader ramifications of this on international law in general?
What does this portend with respect to international law? What is the status of international law after this action taken by the president? Is international law just something that the United States is going to dismiss whenever it chooses to do so and raise as a defense whenever it benefits the government. But otherwise, it doesn't constitute any type of a legal deterrence. And it doesn't appear that international law, at least as the president Trump sees it, is any deterrence to any action that the president seeks to take. I'm equally concerned about, threats that the president is making to other countries, Greenland, Colombia, Mexico, implied threats, which really raise concerns about, again, what precedent this is setting for the future. So if the president can do this, there are no consequences, there's no accountability, then does that embolden him to engage in similar conduct against other countries that he has differences with? It's very unsettling. It's very disruptive to the region.
Thanks so much for joining me today, Jimmy. That's Professor Jimmy Gurule of Notre Dame Law School. The case against ousted Venezuelan leader Nicolás Maduro promises to be an extraordinary legal battle with major geopolitical ramifications. The middle-of-the-night military operation that captured Maduro comes after strikes on Somalia, Nigeria, Syria, Iraq, Iran, and in international waters during Trump's second term. And President Trump indicated there's more to come.
Because we want to surround ourselves with good neighbors. We want to surround ourselves with stability. We want to surround ourselves with energy. We have tremendous energy in that country. It's very important that we protect it. We need that for ourselves. We need that for the world. And we want to make sure we can protect it.
Joining me now is an expert in international law, Jessica Peake, director of the International and Comparative Law Program at UCLA Law School. Jessica, start by telling us whether you think Maduro's capture violates international law.
Yes, there is nothing under international law that allows a state to intervene in the territory of another state to arrest anybody, let alone a sitting head of state. And so I think we have a couple of different significant international legal issues at play here with regard to the US going into the territory and then capturing and rendering Maduro. So the first is that this is really a violation of the prohibition of the use of force under Article 2.4 of the UN Charter. This is both a treaty prohibition and a customary international law norm. And basically, what we have here is a violation of the unlawful use of force and the territorial integrity of Venezuela by the United States, which can be considered an act of aggression. The only way that such an intervention could be legal, or the only couple of ways, is first, if there was a Security Council resolution authorizing the intervention. We don't have that here. And then the second way that an intervention could be legal, if the Trump administration was acting in self-defense under Article 51 of the UN Charter. And that's a right that emerges in response to an armed attack. So that would emerge if the US had in some way been subject to an armed attack by Venezuela. We do not have an armed attack here, nor is there really any credible threat or hint that there could have been a future attack by Venezuela against the United States. So of those two potential justifications for intervention, neither of them are valid or present here.
So, what the United States has said and what Marco Rubio has said is that this was not an invasion, it was not a regime change, it was simply an arrest operation. He said it was a law enforcement function to capture an indicted drug trafficker. Does that support the United States position in any way?
No, there's nothing under international law that allows for a domestic law enforcement operation to be enacted on the territory of another state. So there's just no legal basis for that at all.
Are the U.S. actions here similar to those in the arrest of Noriega?
Yeah, so there's been some comparison between Noriega and Maduro's arrest. And I think there is some factual similarities, certainly, but there are also some significant differences. So Noriega's arrest followed the 1989 U.S. invasion of Panama and led to his extradition to the United States. And when he arrived in the United States, he was indicted, tried and convicted for drug trafficking and money laundering, and ultimately served several years in U.S. federal prison. He was then extradited to France to face other charges and eventually was returned to Panama to serve his sentence there and face additional charges in Panama. Anyway, in that case, the U.S. alleged that Noriega was an illegitimate leader and recognized the candidate that Noriega claimed he had defeated in the election of May of 1989. And in that invasion, Washington emphasized that it was restoring democracy after Noriega had annulled that election. It's very important to note in that instance that the UN General Assembly condemned the US invasion of Panama as a violation of international law. And in addition, various human rights groups, both in the US but also internationally, condemned that forcible extraction of Noriega by the US, taking him from Panama to the United States. The reason that it is a bit factually different here is because the US administration at that time was able to claim that the new government had consented to Noriega's arrest and removal in that manner. And so basically, after Noriega was brought from the Panama to the US, the new government that was installed in Panama was friendly to the US. And so they waived any objections to the circumstances of Noriega's extraction. And that allowed the US to sort of retroactively say that they had consent for those actions that were actually in violation of international law. And because of that consent, that retroactive consent, it quieted a lot of the criticism that had come from the international community.
So here again, the U.S. is claiming that Maduro was an illegitimate president, that he wasn't elected properly. And it seems as if the acting president who's been installed is cooperating, shall we say, with the U.S., complying with the U.S. So is this likely to be another situation where, who's going to enforce the international law?
Right. That's the big question. So we have Maduro still claiming to be president. He was just in court this morning and, he said he had been kidnapped. He said that he's still a legitimate president. We have the vice president or the deputy president of Venezuela was just sworn in, and she is maintaining that she's just there in an interim capacity while Maduro remains president while he's here in the US. And so, certainly their line of argumentation is Maduro is a head of state and he is entitled to head of state immunity and therefore should not be prosecuted in the states of the US. The US argument seems to be that Maduro is a common criminal and doesn't deserve head of state immunity. There's a few challenges to that. Maduro has been recognized as the head of state by the US, and the way that the US has interacted with Maduro over the past year indicates that the US was treating him as a head of state capacity. And it's obviously quite convenient to now change the reasoning on that now that he's in US custody, but I don't think there's really many legitimate grounds to say that he isn't entitled to that head of state immunity. I think we're going to have a little bit of a conflict here between international law and US law, because under international law, the doctrine of head of state immunity, it shields sitting presidents from arrest and prosecution. And this is really designed to prevent this exact type of action. It is designed to prevent third states from intervening in the domestic affairs of another state by exercising any kind of jurisdiction over heads of state and other senior leaders. This is a customary international law obligation. The International Court of Justice has recognized head of state immunity in the arrest warrants case back in 2002. But we have a US domestic law doctrine called the Kerr-Frisbee doctrine, which allows somebody to face trial in the US courtroom regardless of how they arrived here. So if Maduro was forcibly taken in violation of international law, which he indeed seems to have been taken in violation of international law, US courts could still legally prosecute him on US soil. And so, we don't know yet how the judge that has been assigned the case will deal with this international law doctrine of head of state immunity, or whether, the political preferences of the current Trump administration will be weighed more heavily than the international law obligation.
So we've seen Russia go into Ukraine. We've seen the war in Gaza. No one seems to be enforcing international law.
Yeah, it's a huge problem. And this is really another example, and those two that you just mentioned of Russia going into Ukraine and Israel in Gaza, these are all examples of the degradation of the international legal system. The international legal system was really founded on the principle of non-intervention. And we are increasingly seeing powerful states flouting that obligation with very few consequences. And the reason that there are few consequences is because the way this international law system was set up is flawed. And we can see that that is flawed now, 75 years on. The UN Security Council is meeting to discuss this situation. This meeting was requested by Colombia and was backed by Russia and China, which is quite interesting given the actions of Russia in Ukraine and potential future actions of China in Taiwan. And, the UN Security Council is able to impose sanctions on countries to maintain international peace and security, and that would include things like arms embargoes or trade and travel restrictions. But, and this is a huge but, the US is a permanent member of the Security Council and as such has a veto power. And so any action at the UN Security Council or any potential action, talk of action, will immediately be vetoed by the US. This is similar to what we've seen in the case of Ukraine, where Russia, who is also a permanent member, has been able to veto any action. And the US has vetoed action against Israel over what has been going on in Gaza for the past few years. A similar thing would happen if China were to do a similar kind of action in Taiwan. China would also have a veto power in the Security Council. And so we're seeing these very powerful veto-wielding states acting in contravention of international law with really very few ways for them to be meaningfully reined in. What we are seeing and will continue to see is condemnation from other states, criticizing the US for this violation of international law. But also there, we're seeing that watered down too, because many of those condemnations are coming alongside some level of praise for the removal of Maduro, who has been an authoritarian dictator who has treated his people terribly and has led to horrific circumstances in Venezuela. And so we're not seeing the full-throated criticism of this action that I would have liked to see, where states were really coming out in favor of, the status quo of the international legal system being applied. One other thing to say is, we do have the United Nations General Assembly, and we were talking earlier about the Noriega case. And in that case, the UN General Assembly did issue a resolution that criticized the US for its violations of international law for that invasion of Panamanian territory. So it's possible that we might see a similar UN General Assembly vote on a resolution to condemn the US actions here. Usually, UN General Assembly resolutions require a simple majority to pass. But if it is an important question, like the maintenance of international peace and security, and the question that we have here, then a 2/3 majority is required. So if the UN General Assembly were brought together to vote on this, it would require 2/3 of states to vote in favor of a resolution. Whether or not we'll get that, who knows? I don't have a crystal ball to see. I think, though, if there is a UN General Assembly vote and even, a simple majority of states vote to condemn US action, that is quite powerful. That is quite a powerful indication that the international community is not just going to sit quietly while the US violates a very fundamental bedrock principle of international law.
It seems that President Trump and Secretary of State Marco Rubio are not concerned about that because Trump gave a warning to the Colombian president, and also there was talk about Cuba. And on Sunday, he said he reiterated that the U.S. needs Greenland. So he seems to be broadening rather than narrowing his focus.
Yes, absolutely. And I was been very alarmed to see those kinds of statements being made about Cuba and about Greenland. I think that is a symptom of the lack of condemnation for these types of actions. It is really President Trump sort of stretching his powers to say, well, I did it here in Venezuela and I'm going to continue doing it, and who's going to stop me? Which I think is a super valid question. Who is going to stop him? It's pretty unclear at this point. I think the question of Greenland is going to be a very interesting one, though, because it's right on the doorstep of Europe. The Danish Prime Minister has come out extremely strongly against all of the saber-rattling that has been happening around Greenland for the past several months, and over the weekend, came out even more vocally against what the Trump administration was saying. And, the US has no claim to Greenland for reasons of US domestic national security. That is just not how this works. And I think I've seen mention of possible invocation of, Article 5 of the NATO agreement, which would require all NATO member states to resist any military intervention into a NATO member. That's obviously incredibly complex because the US is a NATO member state, although Trump has for many years been saying we should pull back from NATO, and we've already sort of rolled back some of our obligations there. So it might be that Greenland is the stretch too far for this, because I think there's a lot of other geopolitical issues that brings up and that would impact more strongly on some of our European allies, if we're still called allies. I mean, one thing that you've probably heard from other commentators too is that we can see the hypocrisy of this action very clearly if we look at what happened with the Honduran president, right? He was extradited to the US on very similar charges. He was tried and convicted and sentenced in the US to 45 years in prison. Just last month, President Trump pardoned him for those actions. And now we're trying to bring another case against another sitting head of state for very similar behavior. And so it just really shows, I think, the hypocritical nature of the Trump administration's action with regard to Maduro in this case.
There's a long way to go here. And thanks so much for joining me tonight. That's Jessica Peake, director of the International and Comparative Law Program at UCLA Law School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcasts. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.